All right, welcome back. I am very pleased now to introduce our keynote speaker today, Gurbir Grewal. Since July 2021, Gurbir has served as the director of the SEC's Division of Enforcement. Prior to joining the SEC, he was the Attorney General for the state of New Jersey. He also was previously the Bergen County prosecutor in New Jersey and an AUSA for the District of New Jersey and the Eastern District of New York. Gurbir, we're really grateful for you to take your time and come join us here today, and really look forward to your remarks. Will you please join me in welcoming Gurbir Grewal?
Good afternoon, everyone, and thank you, Bruce, for the invitation and for that very kind and short introduction. The last time I spoke at an SEF forum, it was out in California, and Joe Grunfest introduced me, and it was really something. He sort of incorporated how he met his wife and the attorney-client privilege, and you know, it was, so this is considerably less unnerving than that particular introduction. And when I spoke at SEF, I spoke about lawyers behaving badly, and I heard that former Director Kazami is here, and it was the sequel to his speech. I'm not going to give the trilogy, the third part of that today. I'm one of those people who thinks that Godfather 3 was a mistake, so I'll leave it at 2 speeches about the behaviors of lawyers. It's a real pleasure to be back with you in person. And as is customary, I have to say that my remarks today are mine alone and express my views as the director of the Division of Enforcement, but don't necessarily reflect the views of the Commission, the commissioners, or the staff. Now, throughout my first year as director, I've spoken often about the public's declining trust in our institutions and in our financial markets. And I've observed that while there's no single cause for this decline, it's in part due to this perception that we, the regulators, are somehow failing to hold bad actors accountable, and the perception among some that there may be 2 sets of rules, one for the big and powerful and another for everyone else. And in those speeches, I tried to outline the steps that we at the SEC are taking and have taken to address this decline in public trust. During my speech last May at SEF West, for example, I spoke about the need to push the pace of our investigations so that when the public reads about wrongdoing or corporate misconduct, they know that we'll move quickly and efficiently to investigate what happened and to hold bad actors accountable. That's even in the most complex of cases. This is so critically important right now, given the volatility and the uncertainty we're experiencing across the financial markets and in the crypto market. So today, I'd like to talk about how we are working with that sense of urgency to restore public trust by doing 3 things. First, we're doing it by obtaining penalties and remedies that deter misconduct, that meaningfully hold bad actors accountable, that protect investors, and where possible, help harmed investors recover losses. Second, we're doing it by proactively investigating and charging cases across a spectrum of market participants and harm. And third, we're doing it by incentivizing proactive compliance and meaningful cooperation, because this, after all, is a shared endeavor. We can't do it alone. And obviously our work is not done, but I think that we've made some real progress over the course of this past fiscal year, which closed on September 30th. Now, with respect to penalties and remedies, simply put, they must be adequate to both punish and deter misconduct. If market participants think that getting fined by the SEC is just another expense to be priced into the cost of doing business, then penalties are neither effective punishment nor deterrence. Market participants must realize that complying with the securities laws is cheaper than violating them. This must be true not only in cases involving fraud, but also in cases involving negligence. Because after all, investors are harmed equally, whether or not someone violates the laws with bad intent or simply through negligence. So this past fiscal year, we sought to recalibrate penalties to more effectively promote deterrence, and to get away from that idea that penalties are just another business expense. And to that end, last year we recommended, and the Commission issued, orders imposing nearly $4.2 billion in penalties. This is the highest amount of penalties ever ordered in a single fiscal year, and it's more than the prior 3 fiscal years combined. We don't expect to break this record or to set new records each year, because we expect that the effect of that number, of that recalibration, is to change behavior. We expect, as a result of these efforts, increased compliance. If you look, for example, at our off-channel communication sweep, when 17 major Wall Street firms are fined in excess of $1.2 billion, required to admit their failures, engage consultants, and implement safeguards to prevent future violations, not only do those firms improve their practices and their culture, but other financial services firms take note and do so as well. And not only that, the media takes note. And important to trust building, the investing public sees accountability. Similarly, when 3 senior Allianz portfolio managers allegedly orchestrate a multi-billion-dollar fraud scheme that resulted in billions in investor losses, the penalties have to be meaningful enough to deter Allianz and others, and to demonstrate accountability. That's why, to settle fraud charges in that case, Allianz was required to admit that its conduct violated the federal securities laws, and to pay $675 million in civil penalties, one of the largest in an SEC fraud case since the days of Enron and WorldCom. And when gatekeepers, at the gatekeeper, engage in a massive cheating scheme for the second time in 10 years, on, of all things, the ethics portion of the CPA exam, and when that gatekeeper withholds evidence of that misconduct from us, then we need to not only increase the penalty from the last violation, but we also need to incorporate additional remedies, because that's what's required for accountability and for deterrence. And that's why the Commission required EY to pay a record $100 million penalty, admit its misconduct, and implement extensive remedial measures to address the firm's ethical issues. I want to pause here for a second, because I don't want an important aspect of the 19 resolutions that I just talked about to get overshadowed by the penalty amounts. Each of those 19 resolutions involved admissions of wrongdoing. Admissions are an incredibly powerful accountability measure, and you should expect us to continue seeking admissions in similar cases. And as I've said before, we are intentional and thoughtful when we put admissions on the table. It's not to gain an advantage in our negotiations. In those cases where we put admissions on the table, we'll litigate those matters. While the examples I just talked about involved penalties against companies and firms, holding individuals accountable is also critical to our trust-building efforts. As in prior years, more than 2/3 of the SEC's standalone enforcement actions over the past fiscal year involved at least one individual defendant or respondent. And these individuals included senior company executives, like the former CEO of Boeing, who was charged with making misleading statements about the safety of Boeing's airplanes after crashes that took place in 2018 and 2019, and ordered, as part of that resolution, to pay $1 million in penalties. But more than financial penalties is required to ensure accountability for senior executives at public companies and to incentivize them to prevent misconduct at their firms. That's why the Commission employed another tool in fiscal year 2022 and used Sarbanes-Oxley 304 to require several executives to return bonuses and compensation following misconduct at their firms. And that's even though those executives were not personally charged or otherwise involved in the underlying misconduct. For example, 3 former senior executives of infrastructure company Granite Construction were ordered to return nearly $2 million in bonuses and compensation after their company restated financials following misconduct by another former official. And again, of course, a penalty is just one of the tools available to us when we seek to impose remedies against bad actors. We also seek disgorgement from market participants. We seek disgorgement to ensure that they don't profit from their violations of the securities laws. And where appropriate, we'll continue to aggressively seek disgorgement of all ill-gotten gains, regardless of whether the violations were rooted in scienter-based fraud or negligence-based fraud. And last year in total, the Commission ordered nearly $2.2 billion in disgorgement of ill-gotten gains. For example, as part of the global resolutions in the case against Allianz that I mentioned a moment ago, Allianz and its parent company agreed to pay nearly $350 million in disgorgement and prejudgment interest. Again, that's in addition to the $675 million civil penalty. And here I think it's helpful to talk a bit about the interplay between penalties and disgorgement. For the 5 fiscal years prior to this last one, the Commission typically ordered more than twice as much in disgorgement as it did in penalties. In other words, for each dollar in penalties ordered, the violators had received more than $2 in ill-gotten gains. Now, to me, that ratio is backwards, because it means on a macro level that the potential reward for getting away with violating the securities laws was much greater than the potential downside of being caught. If you get $2 for violating the law, but are only fined to pay $1 when you get caught and required to return ill-gotten gains if you're caught, some people may see that as a calculated risk. As demonstrated by the Allianz matter, that ratio flipped last fiscal year. The $4.2 billion in penalties that the Commission ordered is nearly double the $2.2 billion in disgorgement it ordered, meaning that the potential consequences of violating the securities laws are significantly greater than the potential rewards. So while total disgorgement was slightly down from the prior year, it's the first time that the amount ordered to be paid in penalties has been double the amount ordered to be paid in disgorgement. I understand fully, and Joe will remind me, there are legal developments that have affected the Commission's use of an ability to order disgorgement. But whatever the reason, this increased penalty to disgorgement ratio demonstrates that the risk-reward calculation is not what it was just even a few years ago. Another way in which we're working to address the declining trust in our financial markets is by conducting proactive enforcement sweeps and initiatives that specifically target recurring issues or particular risk areas. You see, filing multiple coordinated actions simultaneously not only demonstrates accountability, but has a more pronounced deterrent effect than if the Commission filed separate standalone cases at different times. For example, we've already discussed the sweep that led to charges against 17 Wall Street firms for widespread record-keeping failures. I suspect that it's generated conversation at this conference, and will do so at others. I suspect that it's generated conversation among compliance officers and in boardrooms and at law firms. Another recent sweep conducted by our asset management unit underscored the importance of meeting custody obligations to secure client assets and to protect investors, an important risk area for all of us. That initiative led to charges against 9 registered private fund advisors for failing to comply with the custody rule and or update their Forms ADV to accurately reflect the status of their private fund clients' financial statements. Given the attention-grabbing nature of these sweeps, you can expect to see us employ these strategies more frequently moving forward. But in the end, robust penalties and innovative enforcement actions alone can't restore trust in our financial markets. We absolutely need market participants to help by self-policing, and when things go wrong, to meaningfully cooperate with our investigations. So even as we seek robust penalties to deter misconduct, we must continue to have a robust cooperation program which can bring significant benefits to cooperators, including reduced penalties. While meaningful cooperation starts with self-policing and self-reporting, it doesn't end there. It also means proactively cooperating with our investigations and remediating violations. Since I spent the bulk of my speech at SEF West talking about the ways in which the defense bar and their clients could do more, I think it's only fitting to end this one by detailing several cases from the last fiscal year where firms and lawyers have meaningfully cooperated with our investigations. And the Commission credited that cooperation through reduced penalties or in some cases through no penalty at all. In one case, announced last February, the Commission charged Baxter International with engaging in improper foreign exchange transactions and misstating the company's income. The Commission agreed in that matter to substantially limit the penalty imposed for the wrongful conduct due to Baxter's self-reporting, its cooperation with the investigation, and the remedial measures it undertook. As the charging document in that matter stated, Baxter provided substantial cooperation to the investigation by, quote, by providing detailed explanations how the FX transactions worked, by summarizing witness interviews, and providing other relevant information to the staff, both on their own initiative and at the staff's request. And as I mentioned, in appropriate situations, meaningful cooperation can mean no penalties at all. For example, the Commission charged ProPetro Holding with failing to properly disclose executive perks and stock pledges that its CEO received. The Commission agreed not to impose a civil penalty on ProPetro for its wrongful conduct, thanks to its cooperation and thanks to its extensive remediation. Our enforcement action against Headspin is another example. Because of that company's significant cooperation, the Commission did not impose a penalty on the company for its wrongful conduct. These last few examples are important because I hope they illustrate that while the Commission, these last few examples are important because they illustrate that the Commission continues to reward meaningful cooperation. And given the record penalties we've talked about, there should likewise be an emphasis on those cases in which cooperation has led to no penalties at all. I hope this is a message that each of you in private practice will take back to your clients and to the companies that you represent. I want to thank Bruce for the invitation to speak with you this afternoon. I want to thank you for this opportunity to talk about lawyers, or at least finish by talking about lawyers behaving properly, or as they should, and the examples of meaningful cooperation. I look forward to hearing from the other speakers this afternoon and to hopefully connecting with each of you or some of you during a break this afternoon. Thank you.